Thank you, Adam, and good morning, everyone. Thanks for joining us. This is our early autumn edition of Workers' Comp 202. We are going to dig down below all those fallen leaves and get into the real details of workers' comp. We will be giving you additional illumination on many of the topics that we cover in that 101. So check out our webinar page on our website and register for any webinars you think are appropriate for you, yourself, or your team. Our agency does dozens of webinars a month, so we have plenty to offer. The Advocate for Injured Workers. This is where we're going to begin. Well, that's actually me. That's my title. That is how I'm popularly known. I have an office of advocates, an office of people, and we help workers with the more difficult and complex claims. We try and help you access those benefits. We explain things. My technical title is actually ombudsman. So an ombudsman is someone who is concerned with the health and sanctity of the system. That's me. There's also an advocate for business. He is also an ombudsman. We are two ombudsmen at this agency. I think in all of New York State government, there are only 3 or 4 ombudsmen amongst our 119,000 employees. So we both are concerned with the health and sanctity of the system, and we both report directly to the chair of the board, the head of the agency. My office is involved in fatality claims. Fatality is a benefit that it's going to be the most serious thing in our system, and we do take that very seriously. And we also work a great deal with the 9/11 community, because if you don't know, I have this unfortunate duty to tell you this is still ongoing. So we're drawing your attention now to the webpage on our site that has some information for 9/11 responders. Moving across from the left, there is a World Trade Center health program that is funded by the federal government. If you were there, would you please contact the World Trade Center health programs to at least arrange for monitoring of yourself? It is really that important. There's a September 11 Victim Compensation Fund that is operated by the Federal Department of Justice. And then finally, on the right, you can see that we're calling out the World Trade Center Volunteer Fund, which we administer here at this agency. Of course, there are benefits for paid workers, but World Trade Center is the one place where volunteers may also have a workers' comp type benefit. Okay, so moving on, let's get into another element here. This is something we speak of in the 101, but it's so important, I'm going to spend a moment on it again, which is how do we create safer workplaces so that we never have an incident to begin with, which is everyone's preferred scenario. We can all agree on that one. Well, here's an easy and free way to do it. Why don't you form a labor management safety committee? We have some suggestions on screen here for what you might want to do and how you might want to do it. But the important thing is, think about safety. Think about mitigating accidents before they ever happen. Get out of the conference room, go in the workplace. Review what you're doing and how you're doing it. Try and identify potential threats to employee safety and mitigate them. That means eliminate them. Also, we suggest you probably review your equipment and your procedures and how you're training people to make sure you are training everyone to operate in the safest manner possible. We have more education for you. We mentioned our website. We're going to draw your attention now to the point in our website where we list our various publications. And you can see we have a slew of them here devoted to workers, but if we continue paging down, you'll notice that we have publications for employers. We have all the medical treatment guidelines. We have the impairment guidelines. Look at all this good stuff that we have, including our annual reports towards the bottom. So we commend this to your attention because we probably have a fact sheet on whatever individual topic you're interested in. I say probably because I'm thinking of one I'll tell you about later where we don't. But if you think we should have something, why don't you feel free to let us know that? Outreach at wcb.ny.gov?
That it is.
Adam will show you some addresses later. But if there's something you think we should have, feel free to ask for it. Now, you're a worker. You have a claim. Why don't you register for eCase so that you can see all your claim documents? Spectacular idea, isn't it? Well, it's really a pretty simple matter. Here's the web page. You click register for eCase. You fill in these blocks. You're going to have access to your claim folder. You will now see everything that the rest of us see when we access your claim folder. It's going to eliminate a ton of questions. It's going to get you ready access to what you're looking for. Really recommend if you have a claim, you do this. There are some privacy provisions in the workers' comp law that I'd like to review. The workers' comp law is what we follow with respect to privacy. So if you're coming from a medical practice, yes, you have HIPAA in every other endeavor. Over here, you have the workers' comp law. We don't do HIPAA here. We have Section 110A of the workers' comp law. So I'm pointing this out because there are advocates and other people who want to help workers with their claims. And that can include, say, the spouse of an injured worker. Well, workers' comp law says we can only discuss claim details or even verify the existence of a claim with the person who suffered the claim is called a claimant in insurance jargon. So the claimant or the claimant's attorney, the employer, yes, employers have access to claim data, of course, and the insurers and insurance attorneys and the providers of the health care. Other than that, if you want claim details, well, you can't have them unless the worker authorizes you to have them. And the worker authorizes you to have them by filing Form 110A. Here it is. So, if you're someone who works with injured workers and you want to help, get a 110A. Ask the worker if you can have access to claim details. The worker says yes. The worker, not you, the worker will complete this form and designate you. And this also pertains to elected officials, by the way, because we do hear from elected officials who are trying to help their constituents. So if you want to help, get a 110A from the injured worker. It's fillable online. There's a Spanish version too. I'm sure we must have other versions as well. It'll go in your claim folder. We'll see it, and then we can speak with you. We are going to do the benefits now. We're going to spend a great deal of time on indemnity, or the lost wage benefit. Then we'll move to medical, and then we'll move into some other areas of the comp system that you ought to know about. So let's begin at the beginning. Let's say there's a controversy filed. Claim comes in, the insurer takes a look at it, the insurer decides, we would like to challenge this one. We would like to dispute this one. This is a controversy, and in our system, we say that the claim has been controverted. Okay, for those of you taking notes. All right, here's what you need to know if you're a worker. Number one, no benefits are going to be paid until this is resolved. Yes, no benefits will be paid your way And the insurer is not going to be paying the medical providers either until the claim is decided as either ultimately payable or compensable, as we say, or if it's not going to be considered a comp claim, it will be disallowed. Now, if an insurer wants to controvert, it has to cite one of a limited number of reasons. I think there are 16 or 18 of them, and many of them are very similar. But the point I'm making to you here is that the insurer must specify what it is objecting to. Now, if this happens, almost all of them are going to go on what we call an expedited calendar. The 2007 reforms addressed what had been a long-standing problem in the system of the length of time these things took. So now the law says we should be wrapping up all that fit within these criteria within 90 days. And the good news is we do. We largely do get these wrapped up in 90 days or less. But remember I said the worker's not getting any income? Well, what's the worker going to do for income? Well, don't forget that there is short-term disability potentially available to you. So if you look at your pay stub and you're contributing 60 cents every week or two for short-term disability, you're eligible. So if you have an injury that is preventing you from working, you can file for short-term disability. Now, it's going to bring you $170 a week, but it is $170 a week at a time when you might have zero income from work. So you can do this. And then if your claim gets established, the two insurance companies will talk to each other and exchange funds. The insurers are very good at this. So don't worry about that if you are a worker. So we just want to point this out to you that you do have that available to you. In a time of controversy, okay? In a time of controversy, because your claim's not yet been established, it's being disputed. That's why you can go to short-term disability. Let's talk now about an instance where the claim is established or it is receiving benefits. There is something known as a CCP. That is an acronym that stands for Carrier to Continue Payments. The carrier is the insurer, okay, the entity who's paying the money. Continue payments means a judge has said at a hearing that the payer should continue to make this payment in this amount moving forward. No one can change that order except another judge or if it's appealed. But the point is, to change that order, there's going to have to be a board action. The payers cannot unilaterally decide they're going to stop paying, and the payers do, on the whole, know this quite well. In my experience, they don't violate this. So just want everyone to know, if you see an order that says carrier to continue payments, you're going to continue receiving that payment into the future until there are circumstances that change it. Now we're going way down. This is the big stuff. If you've ever gotten a comp check, or if you're seeking one, or if you've ever paid one, or represented someone, now we're going to talk about what the money is and how it's calculated. Okay, and I'm hoping that the providers, the medical community who's on here, because I know a bunch of you are, and thank you very much for coming. I'm a big fan. Providers play a pivotal role in this, so here we go. The worker's been injured or ill, but let's just say it was a traumatic injury to make it simple, okay? So the worker has a traumatic injury, maybe fell and broke an arm in the workplace, and goes off to an urgent care or an emergency department, gets treatment. Whatever happens, the doctor has to indicate a degree of disability. How disabled is this person? Now, it's going to be expressed probably as a percentage. You see the table there? See on the right side I have percentages? On the left side, we have the English equivalent, and old-timers in the system will sometimes use the word rather than a percentage, and that's okay because we know what the words mean. Okay, this is pretty well established. But the provider is going to state how disabled the worker is as a percentage. If the provider says the worker is 100% disabled, that's what we call total, and the worker at this point would be on temporary total disability, and so that would entitle the worker to the full benefit. However, someone could be 75 or 50% disabled, even on the first injury, or as time goes on and the worker heals. That can happen, and it So that disability between 100 and 0, 0 means you're healthy. Go back to work, please. Now, how does the degree of disability impact your benefit payment? Well, here we go. We're going to do some math now, folks. If you are totally disabled, you're 100% disabled, you're going to get 100% of the potential benefit. And of course, the benefit would be 2/3 your average weekly wage. But let's say you're 75% disabled, you're getting 3/4 of the benefit rate. And then you can see on the chart how it moves down. So this is one reason why it is so important for the providers to file these degrees of disability. We're going to talk more about that in a moment. I'm going to show you how. But also, please remember that your rate is capped at the maximum rate that was allowed for your date of accident. So these are all based on date of accident. Now, we're going to give you a quiz, and Adam's going to take over.
Thank you, Joe. You're going to see on your screen here, we have a scenario about Susan. We want to get your thoughts on this. So Susan was 100% temporarily disabled, and she's been receiving $1,000 a week for the last 3 months. Susan's doctor recently said she has healed to the point where she is now 50% disabled, and Susan has never had a workers' compensation hearing. And so we want to get your thoughts here. True or false? Because of her new disability percentage, Susan's benefit will now decrease from $1,000 per week to $500 a week because she has gone from fully disabled to only 50% disabled. You'll see a poll come up on your screen. I see we already have people answering the question here, Joe. We're still going to give people a couple seconds to get their answer in. We just want to know true or false. Right now, it looks like we have the majority of folks are saying true. It looks like about 75-25% split.
Well, let me take a look at the question and see if I can do the math.
Sure.
100% disabled. She's getting $1,000 a week. She's now 50% disabled. Okay, spoiler alert. Her benefit will probably drop down to $500 a week. So that makes the answer true.
That makes the answer true.
If the carrier was extraordinarily generous and wanted to keep it at $1,000, they could. But Susan is now 50% disabled, which would create a 50% benefit scenario, which based on the simple math we use there, that's $500 a week. So we do this quiz to show you that as people heal, their disability levels will change, and then the benefit will match it, which means in this instance it's going to go down. However, we should do a quiz with this one. If Susan had been 50% disabled and then she had an inpatient surgery, well, her benefit ought to rise to 100% because she's recovering from surgery and she can't work. So that happens too, my friends. The math works both ways. Maybe we want to do that.
Stay tuned, folks.
Yeah. Okay. Now, I'm speaking directly to my friends in the provider community. This is one of the most important things that happens in the life of a claim. When a worker is temporarily disabled, okay, so it's probably the beginning period of, no, it has to be the beginning period of the claim. The worker must see the treating provider every 90 days at a minimum. Obviously, if you need to see the doctor every 3 weeks for ongoing treatment, please go. But at a minimum, you should be seeing the doctor every 90 days for care, number one, and number two, for an opinion on how disabled you are. Remember I said your benefit is based on your degree of disability? Now we need to talk about how that comes in. Providers, you've treated the patient. You're going to file two things. You're going to file two things for the workers' comp system. Number one is the CMS 1500, the billing form. Thank you very much. Number two, we need a little bit of a report. Yes, you can file your treatment notes, and sometimes you have to. But please make sure that these three questions are addressed in your treatment notes, or you can use this report template that we are showing you on screen to answer the three questions. Number one is work status. Is the patient working? Yes, no. Causal relationship, that's the second one. Okay, is what you're treating the reason why the person can't work? Is this a work-related incident? Okay, that's that. But then number three is temporary impairment percentage. That is the formal way of saying degree of disability. So this is where you're going to indicate it. And if you do not indicate a degree of disability, if there's no CCP in place, the payer can stop the payments. Okay, you see that the first bullet there? Benefits can be halted without a CCP. Well, this is the importance of this document, of these elements, of these opinions. So this is me very nicely asking all the providers who are in a position to give these opinions. Because, for example, a physical therapist doesn't give these opinions. However, an internist certainly does, an orthopedist certainly does. So please remember to either use our template, which you can get on our website, or incorporate these questions into your templates for your treatment notes or your office notes or whatever. We need these. Your patients will thank you. All right. Permanent partial disability. This is an extension of the indemnity thing, but I need to explain what permanent partial disability is. There was an injury 3 years ago, and the worker has been healing for 3 years, and now we come to the point where the worker is, according to the opinions of the doctors, permanently and partially disabled. So that means that It's not a total disability. It's not 100% disability, but there is a partial disability, so somewhere less than 100%. That is going to entitle the worker to a specified number of weeks of benefits. Now, you can see on the right-hand side of your screen the percentages and the number of weeks that they yield. So if a worker is found permanently partially disabled, the smallest amount of weeks is 225, which is just over 4 years, and the maximum is 525 weeks, which is 10 years, roughly. So between 4 and 10 years of benefits, and it's based on LWEC. LWEC, if you ever hear anyone say LWEC, they are talking about the loss of wage earning capacity. Now, LWEC is calculated through a relatively complex formula that we are not reviewing here because it's really not going to help us to review that formula here. However, the good news is all of our judges know how to do it, and it's all the attorneys who might represent workers or who represent payers too, all the attorneys know how to do the formula too. So I respect that in all of you. But what we're showing is a worker with a loss of wage earning capacity between 96 and 99% at the top, that's going to get 525 weeks of benefits. All the way down to the bottom, the 1 to 15% is the loss of wage earning capacity. That'll get you the 225 weeks. Once you're getting these weeks, if you go back to work, the clock stops. So let's say you're 15%, you've suffered a 15% loss of wage earning capacity, you were awarded 225 weeks. Okay, so you got 25 weeks of benefits, and then you got a job that you could do, so you go back to work, and the clock stops on your permanent partial weeks. If it turns out you can't do the job, well, I'm sorry about that. So then the benefits could resume. However, people who are permanently partially disabled, obviously there's a health challenge there. Their health could deteriorate. So as you're going along with these permanent partial disability benefits, workers, do be mindful of your health, and if you suffer a change in condition, let's say you had an 85% LWEC, so you're pretty injured if you've lost 85% of your capacity to earn a wage. Okay, so 85%, that's going to yield 450 weeks. 9 times 5 is 45. That's roughly 9 years of benefits. Let's say over those first 7 or 8 years, your health declines. You can file for what's called a change in condition, and you can seek permanent total disability. This is possible. This has happened. I have helped several workers do this with, of course, the aid of their attorneys who did the hard work. But point is, if your condition changes, either talk to us about how to do this or talk to your attorney if you have one, absolutely, because if a doctor is telling you, you know, I think you're now permanently totally disabled, you can pursue that to get the permanent total disability benefit. And the difference is permanent total gets you 100% of the possible benefit, and you get it for life. So that's why I'm calling it out. I'm also calling out another benefit here, the second bullet. It's known as total industrial disability. This is also a 100% benefit for life. It is a little bit different than the permanent total. because total industrial disability takes some other factors into account, such as languages and education, and maybe is it feasible to retrain at your age? There are factors. They do get litigated. You will have to have a hearing or two on this. This is a place where if you have an attorney, you need to speak to the attorney. If you don't have an attorney, if you've never had one, this is a point where you might want to talk to an attorney to help you out with this one. However, this is just us calling out to you and reminding everyone that these benefits are on the books, they are possible, and yes, I have seen them awarded. Now, here are some best practices with respect to indemnity payments. And then from here, we're going to go into labor market attachment. So, before we do that big topic, here are 3 quickies. Number 1, if you're a worker and you're getting checks or you're getting payments or you're getting checks, if you're getting paper checks in the U.S. mail, would you please consider using direct deposit if you can get a bank account? If you can get a bank account, would you please consider using direct deposit? There must be a reason why I asked you twice. It's because this solves all your late and missing check problems. If you represent injured workers and your client can have a bank account, would you please consider discussing the virtues of direct deposit with that client? Second, let's say you're a worker and you get paid in cash. That's fine. Cash is still legal tender. Not everybody gets paid by check or any other electronic means. I'm recommending that you keep your own records of your cash salary. So it's pretty easy to do. You really just need either a notebook or an electronic file, and I'm recommending that you note who paid you, how much, what day, for what reason or for what service or for what weeks worked. Really recommending you do that, because if you ever have to, let's say, file a comp claim, we're going to need to know what you were earning. If you have records and someone else does not, well, that could be pretty persuasive. Plus, it's probably factually correct, so if we want you to do things in a factually correct manner. We have a question, Adam. Why don't you read that last question?
Someone wants to know how you can get direct deposit. They've inquired with an attorney, but they're curious about the time frame and how to apply.
Well, okay, so you checked with your attorney. That means your attorney is probably checking with the insurance payer, because this is arranged between the worker and the insurance payer. And yes, I understand workers who have attorneys, the insurance payers deal with the attorneys. Okay, that's great. So insurance payer, if you are SB's insurer, that's the initial of the person who wrote us, the insurers should be, hopefully, I know there are some, okay, the insurers, I hope, and I do see some doing it regularly, telling the workers, here's how you register for direct deposit. Some insurers have you go to a web page and fill in some criteria. Some insurers have paper forms they'd like you to complete or online forms. Either way, this is between the worker and the insurer. So SB, your attorney is probably trying to get the info directly from the insurance payer. Now, there's one more thing we want to cover on here. This is really, really helpful in instances where maybe the carrier is in dispute. This happens most frequently in construction, but it could happen anywhere. If you're a worker, please note where you're working whenever you go to work, especially if you're a day laborer or especially if you go from job to job, site to site. Please pay attention to the address where the accident happened, because This is something we see happen in big cities where there are multiple contractors on a construction job and nobody knows who's really insuring this worker when this incident happened. Well, workers and workers' attorneys too, by the way, if you know the address where the worker was injured, we, the board, will pull the building permit. Once we get the building permit, everything is pretty clear to us. Who needs to be on notice? Who's probably the proper insurer? Okay, maybe we have to litigate that still, but we're probably having one hearing on that one. So if you're a worker, please pay attention to where you're working. Please don't get hurt, but if you do get hurt, well, this is going to help you get your benefits way quicker. All right, this is a big topic now. This is called labor market attachment. What is it? Well, there is an appellate court decision. It's known as American Axle. And this decision says, and there's some other ones too, by the way, but it says that workers who are temporarily disabled, okay, so we're not permanent, because this does not pertain in permanent disability, permanent partial claims. But if a worker is temporary and partial, the worker could be asked to demonstrate that the worker is seeking employment within their restrictions. The restrictions are obviously the physical or psychological restrictions the worker has. So if we have a worker who's 50% disabled on a temporary basis, the insurance carrier can ask a judge to consider the idea that this worker should be seeking employment. This is coming out of what they call case law, as in the workers' comp law itself does not mandate this. As a matter of fact, the only place the workers' comp law talks about labor market attachment is where it says it's not necessary. But there have been decisions over the last 109 years that led the court to this. So here's what it means. If you're a worker and you are temporary partial and you're not working and you're getting a benefit, if this question is raised at a hearing and the judge says, yes, Mr. Roth, you're going to need to demonstrate your labor market attachment. What it means is you're going to have to demonstrate that you are seeking employment within your restrictions. Now, the third bullet on screen is key here because according to that American Axle decision, workers must demonstrate a timely, diligent, and persistent work search. What does that mean? Well, you'll notice that we have one adverb and two adjectives. So forgive the English professor in me. What that means is it's not stated when is timely, how much is diligent, how frequently is persistent. So the amounts are really going to be a matter of decision. So the type of work search you have to do, we know. The amount of effort, a judge or an appeal is going to, or an appeal panel is going to make a decision on whether you have performed the amounts necessary to continue your benefit. So what do? Well, you can use any and all, talking to the workers here, you can use any and all of these resources to demonstrate that you are seeking employment, that you are attached to the labor market, because you're going to have to demonstrate that you're seeking employment. you can most definitely go to the Department of Labor Reemployment Services. You can use that service. Absolutely you can. Of course you can go to the one-stop career centers. You can also become a full-time college student if you don't have a college degree. Well, this might be the point where you have the opportunity to switch careers. Maybe you've always done this, but now you want a degree in that because you want to move into that field. This might be your opportunity. If you become a full-time college student, that could demonstrate your labor market attachment. That can get your benefit continued or restarted. You can use vocational rehabilitation services, what we call Access VR. In the old days, they called it VESID. And these items, if you are taking advantage of these items, you are going to document them on Form C-258. That's our next to bottom bullet there. So you're going to want to demonstrate it and include it on that document, and you're going to want to file that. And if you have multiple instances, let's say you filed it in August, and now today, October 3, something big happens, you can file another one. Of course you can. We're also recommending that you include a resume in your board filings. That's a very good thing to include, workers, a resume. Or you can also do what's known as an independent work search. That means you're looking for a job directly with employers yourself. Maybe you're using an online resource, you know, Monster or Indeed or one of the bazillion other job search sites, LinkedIn, whatever it is. Or maybe you're seeing some ads and you're directly responding to them. Great. This is your effort to demonstrate your labor market attachment. We have another form that you would want to document this on. It's called Form C-258.1. It's the bottom bullet there. Anyway, the point is, take a look at what's on screen. You're going to want to be capturing these elements probably to demonstrate your labor market attachment. You're going to want to take this work search seriously. My advice is the same advice that we've all heard for a century. If you're looking for work, make looking for work your full-time job. So I can't tell you how frequently you have to search for work. Can't tell you how many contacts you need. That's decided on a case-by-case basis. But I can tell you, if you make looking for work your full-time job, you're doing as much as you possibly could, and hopefully that would help you out here. And don't forget to include the resume and put as much info as possible. The idea is if you're demonstrating your labor market attachment, you're going to want to include as much information in as orderly a fashion as you can to really clearly demonstrate that you are trying. Now, we're moving into one of the last topic as it comes to indemnity, which would be, did you know that there are penalties possible for the late payment of benefits? Benefits should be started within 18 days of the incident or 10 days from when the payer had notice, whichever is later. And the good news is, in New York State, since we have implemented e-claims, which is a solid 8-9 years ago by now, the compliance rate here rose before e-claims. It was 38% of the time benefits were starting on time. But once we put in e-claims, suddenly it rose to 90%. So 9 out of 10 workers should be getting their benefits started on time, and if not, penalties are possible and penalties are assessed. Now, you're a worker and you have a hearing or you have an appeal. It's going to be decided on this day, and then the decision is going to be filed, and the decision will probably be filed 2 days later because we have to actually write it, prepare it, and then it gets a filing date. Okay. If you're awarded benefits, the benefits have to be released within 10 days of the filing date. That's why I'm asking you to go on direct deposit, because let's say you've been getting benefits, they get halted, and then they have to be restarted. If your direct deposit is in place, you're going to get the benefit within those 10 days. But if this is your first time ever getting the benefit, or you get checks in the U.S. mail, well, guess what? The check will get printed and postmarked on day 10, and then you're going to have to wait for, the mail to get it to you. If you're receiving ongoing benefits, 25 days. So if you're getting paid every 2 weeks and your check is, in your estimation, late, you're used to getting paid on a Tuesday, and now it's Wednesday and Thursday and Friday, and the check's not there, there are a number of things that could have happened. But point is, it's not officially late and subject to a penalty until it's 25 days late. That's why I'm saying please get direct deposit. And also, interest can be due after an appeal. So let's say there's an appeal, your benefit was hung up there, delayed workers, but you prevailed. Well, interest could be due to you and could be due to the providers who didn't get paid as well. Speaking of providers, let's talk a little bit about the medical treatment guidelines. Now, number one, we have webinars devoted to the medical treatment guidelines that explain them in detail, that explain elements of them. That's not what I'm going to be doing here. That's not my area of specialty. However, we are showing you that we do have those medical treatment guidelines available online, and here's the web page where they are, and there are 16 of them at the moment. So there are 16 different medical treatment guidelines. Here's some info about the process, though, that everyone should know. Number one, the providers are filing for the prior authorizations. There are plenty of services or circumstances that require a prior authorization. For example, if the treatment the doctor wants to do varies from the guidelines, yeah, you might need a prior authorization. If the treatments cost more than $1,000, you might need a prior authorization. There's a review process, and we're going to talk about that next, but it's the providers who file for this, and they use software that we call Onboard. So we rolled out some new software last year that got us out of the paper form world, which a lot of us celebrated. So now let's say that the provider is filing for the authorization. This is important. It's going to potentially contain 3 levels of review. Could just have 1 level of review. Level 1, an adjuster or probably nurse at the payer is going to review the authorization request. And if that adjuster or nurse says, yes, authorized, great. Everyone gets notified. Level 1, everything was authorized. Go on ahead, get your treatment. However, let's say that for some reason the level 1 review is denied. Okay, that automatically gets escalated to level 2. Now at the second level, there is going to be a physician at the payer who's going to have to review. And it does happen that based on additional training and education and experience, the physician might agree, yes, this is necessary care, and I'm going to approve this. Okay, so that would mean at level 2, it was approved. Great, let's go get that treatment. But the physician can also say, no, I don't believe this ought to be authorized, and here's the reason why. Okay? Reasons have to be given at each step of the way, and I'm calling that out because if you're a worker or if you're a provider, the reasons are given. So now, let's say it was denied at level 2, and you're the treating provider, because it's the treating provider, the provider who requested this, who has to make the move. You can now either ask for a level 3 review, which means what you submitted is going to move to the board's medical director's office. And our medical director's office is going to review. And they will consider whether it ought to be approved or not. Let's say they approve it. Okay, great, go get your treatment. That's not going to get you into hearings. If they approve it, go get your treatment. But remember, you're the treating provider. You've had 2 levels, and now you've seen the denial reasons. You have to escalate it to the medical director's office, and you have, I think, 10 days to do that. Yeah, it's 10 days. So let's say you make the move and you escalate it, or let's say based on the denial reasons, you realize that there is more information that you would like to submit. There's some clarity that you could submit. Well, you don't have to escalate it to level 3. You could just resubmit it with the additional information that level 1 and 2 didn't have, that maybe you think will get it approved. So you can do that. And even providers, even if level 1, 2, and 3 are all denials, if you think there is some clarity or some additional information you would like to submit, you can just do that and bring it back to level 1. Maybe there's a journal article in a real medical journal, not WebMD, the real medical journals that physicians read, that demonstrates the efficacy of this treatment. You didn't cite it the first time, you can resubmit and cite it the second time, for example. This process also pertains to the drug formulary. It's just that in the drug formulary request system, instead of being known as an MG, it's known as an RX, but it's essentially the same process when using the drug formulary. Can level 2 review be done by an RN? Someone is asking. I don't believe so. I believe it has to be done by a physician at the insurance company. That was a question that just popped in. Okay, that was a lot of information about a very important process. I just want everyone to remember it's the provider who has to make the request, and at any point, the provider can resubmit the request if it's been denied with more information on target. Now, here's another best practice for medical care. Workers, you're going to get care. Would you please arrive at all your appointments with your WCB case number? Okay, that's the 8 characters that we assigned. The insurer is also going to assign its own case number. That's known as the carrier case number. Please arrive at your appointments with that as well. And then finally, please arrive at your appointments with the name of the insurance payer, because your providers deserve to be paid for their services. They need to get this information over to us with the WCB case number, but they also have to get the information to the insurers. And that means they need the insurance case number and certainly the insurer's name. Now, on the subject of well, I don't even know how to categorize this. Let's talk about independent medical exams, because this is a real thing. Workers can be asked to attend an independent medical exam. This is known as an IME. This is when the insurer is hiring probably a physician, almost certainly a physician, but not always a physician, but almost certainly a physician, to review some aspect of the worker's health or claim. Here's what you need to know, workers. Number one, there is no doctor-patient relationship here. This physician is not treating you and is not going to offer treatment ideas to you. You don't have a doctor-patient relationship. That means also you may bring a witness. Now, if you're very ill, it's a good idea just as a patient to bring someone with you to your exam, because you might not follow everything the doctor tells you. But over here in an IME, yeah, you might want to bring a witness, and you might want the witness to record everything. You know those cell phones so many people carry that have all those cameras? Well, your witness could open the cell phone and record your whole visit, and that is perfectly allowed. No one can tell you no, as a matter of fact. No one can tell you the witness cannot attend. No one can tell you no. If you ask the IME doctor if you can record, if the doctor says no, well, okay, you were nice enough to ask, but you certainly don't have to comply with that. You certainly can continue recording. Why do you do that? Well, there's going to be a report generated. You're going to review the report. If you have an attorney, your attorney's getting the report too, and I'll bet you your attorney's reviewing that report and maybe comparing it to the video of the exam, because you just want to make sure that you understand where all the findings are coming from. And just to be pretty on point about things, if you're a layperson and you get a finding in your exam of a degree of disability or, a percentage of this or that, you might not know where it's coming from, even if you watch the video, but your attorney very possibly might, because they do this all day long. So that's why you want to make that video. What's that question that just came in, Adam?
What should a claimant do if an IME refuses to conduct an exam while being recorded?
Oh, well, that's the IME saying the IME is incapable of continuing with the exam. So that's not your fault that the exam did not happen. Repeat, that's not your fault that the exam did not happen. The IME has canceled the exam at that point. So if you have an attorney, you certainly want to tell your attorney. You certainly might want to tell the board so we can put it in your board file, because as I said, you have the right to videotape the exam. If the IME doesn't want to be videotaped, the IME is canceling the exam. But this does get us to the next area, which is if you have a complaint about the conduct of the independent medical examiner, you want to make that to the Office of the Advocate for Injured Workers, i.e. me. So you want to send your complaint to our office mailbox, and it will be triaged by me, and I will forward it to the committee that we have here internally that does review these, because we do have a committee on IME conduct, and they will investigate it. And there was an instance about 2 years ago or 18 months ago where an IME entity did lose its license to do IMEs in this state. The board pulled its license because of conduct that was egregious. So if you don't realize this, my agency does license these entities to perform exams in the comp system, and if something goes very, very wrong, we can pull that license. So that's why If it's a matter of conduct, you want to tell us. If it's a matter of the IME says you're 50% disabled and your doctor says you're 100% disabled, you're going to have to litigate that. That's a difference of opinion. I'm talking about conduct. You know, were you treated properly? Were you injured at your exam? That happens once in a while. Were you seen in a medical facility like you're supposed to be? I'd be very surprised if you were not, but it could happen. We had one famous instance, famous to me and my people, where a worker in a wheelchair was seen in a facility where wheelchairs did not fit into the exam rooms. Okay, that's something that has to be looked into, for example. So the person was examined in the waiting room. That's something we want to know about. And also, workers, don't forget, you can claim travel reimbursement to and from these exams. You fill out the form C-257, just like you do to get travel reimbursement to your medical care. But yeah, you can claim reimbursement to and from these exams, and based on the distances I sometimes see workers asked to travel, yeah, you might want to seriously consider this one. Appeals, new topic. Appeals are possible. I'm going to walk through the appeal procedure now. A judge's decision can be appealed. So number one, we're talking about judges' decisions being appealed. But it is possible for either party, usually the party that didn't prevail, to appeal a judge's decision within 30 days of the filing. So remember I talked about filing dates? That's your trigger. A decision can be appealed within 30 days of filing. If you're a worker and you have an attorney and you want to appeal, your attorney's going to do this for you. That's why you have an attorney. So the appeal comes in, and then the other side gets 30 days to file a rebuttal, and then it moves into consideration by a panel of 3 board members. So the agency is called the Workers' Comp Board, but there is also a panel of 13 people known as the Workers' Compensation Board again. Our chair, the head of our agency, is the chair of that 13-member Workers' Comp Board. They're going to consider it. Now, here's the part you have to know if you're a worker. If the judge said you should be getting benefits and the insurance company appeals that, they're not going to pay you your benefits if that's the subject of the appeal. However, let's say that an appeal is filed, but your benefits are not the subject of the appeal, then yeah, your benefits should continue. There's a little checkbox on the appeal form that addresses that. So the 3 board members are going to consider. This is going to be handled in what's called the Administrative Review Division of the board, or ARD. And if at the end of the appeal it's decided that the worker should be getting benefits, well, the benefits must be released, even if the payer wants to appeal that one. But the benefits should be released. However, it is possible after the first level of appeal to appeal again. Now, technically, you could skip the rest of the process and go directly to the appellate court. But typically, people do go through the process because it costs a little money to file with the appellate court, and we don't charge. So you've been through the first level of review, the 3 board panel members, and this does take some months, my friends, to get that decision. Okay, now you want to appeal again. You can appeal to the full board of 13. And that goes in 2 varieties. Number one, if all 3 panel members agreed, then if you want to go to the full board, That's what we call a discretionary appeal, as in the full board has at its discretion whether it's going to accept your appeal or not. However, if there was a split decision at the 3-panel member level, that's now a mandatory, and that will end up in front of the full board. From there, let's say you don't like the decision, you don't like what the full board has decided, you certainly may go to the New York State Supreme Court, Appellate Division, 3rd Department. You have now left the board. So now you have to conform to the appellate court rules. We can't help you with that. However, the New York State Supreme Court can be helpful to people who want to apply for an appeal there. So you're going to have to speak to them. And then from there, when they make their decision, it's going to come back to the board. And at one of our monthly board meetings, our full board will either vote to accept the appellate division decision, or it might vote to appeal that. That is also within the realm of possibility. So just showing you here what the appeal process is. So just to quickly recap, Adam, because we talked for a long time there, we being me, judge makes a decision. Either side can appeal it within 30 days. That's going to go to 3 board panel members. They make a decision. It's going to take some months for that decision. If you don't like it, you can appeal that to the full board. They might have to definitely take it on a mandatory or on a discretionary. And then from there, if you want to appeal that, you're going into the New York State Supreme Court Appellate Division. You've left the board. Okay, new topic. What's a settlement? What's a settlement? Well, in our system, a settlement is one and only one thing. It is a Section 32 waiver agreement. We mentioned this, we're doing this topic because people use the word settlement rather casually. No, in our system, it's a Section 32 waiver agreement. Adam is showing you the web page where we actually explain this and where we actually have a little video that explains it too. A Section 32 means that you worker are striking an agreement with the payer, not the employer, the payer, wherein you are permanently closing either your medical benefit or your indemnity benefit, or both. And you're permanently closing it for the future in exchange for a payment today. Okay, if you do this, you are leaving the comp system with respect to that benefit. So you can keep your medical care open, because remember, medical care is a lifetime benefit in our system. You can keep the medical open and close out the indemnity portion in exchange for a payment today. But please remember, you can't come back for more benefits. You are permanently closing this. You are leaving the comp system for that. If you close the medical and the indemnity, you've left the comp system. There's nothing we can do for you at that point. The last step in the process is the board reviews the agreement, and then we either approve it or we reject it, but we're only going to reject it if it's either A, legally unsound, or 2, it's unconscionable. Other than that, those are the only reasons we would reject it. We do not negotiate it. We here at the board do not negotiate these settlements on behalf of anyone. So please be mindful of that. And please also be mindful of the fact that if you take this settlement, workers, you are leaving the comp system permanently with respect to what you closed. This is the only usage of the word settlement in our system. We've been talking about attorneys here in the context of workers might want one. Well, if you do, we can't give you a particular name of a particular attorney. That's not permitted. But here you go. Here's how you find one. You can go to the New York State Bar Association. That's how you do it. You can also go to a group known as the Injured Workers Bar Association. These are the attorneys in New York who represent injured workers. There's how you do it. The third bullet, you can retain a licensed representative. A licensed representative is someone who has taken an exam and been approved by the board to represent workers who may not be an attorney. If you want one of them, you need to come to our website and get the list. We're showing you how to do it there. Or the final thing is, let's say you have a medical-only claim. You've never lost time. There's no indemnity benefit. Let's say you're having difficulty finding a worker, an attorney to represent you on a medical-only claim. Well, you can go to the State Bar Association and select workers' comp on the left side of the page, and they will match you to a pro bono attorney, an attorney who will not charge you, who will not take a fee to represent you in your medical-only claim. Because let's say you're having difficulty getting treatment or something like that, and there's no indemnity, so there's no money. Well, if you need an attorney, go to the Bar Association site, as we're saying, and they can match you to a volunteer attorney. Oh, Adam, I think we got a question, didn't we?
Someone's asking how they can apply to be a licensed representative.
Oh, well, check out our website and check out our announcements, because we will announce the exam that you would have to take. But we have a question, don't we, about settlements here?
Oh, we have a few questions about settlement.
Let's just do them now, as long as we're on the topic.
All right. Actually, I'll go back to the slide here then. Let's see. We have, what are some incentives for an injured worker to seek a Section 32 agreement? Why cut off the right to benefit as an injury can worsen?
Oh, well, you're asking me to give you a lot of opinions on that one, and I really can't. This is the kind of thing that if someone offers you a 32, or, you know, if you might want to think about it yourself, you might have a compelling reason to take it. That's a personal choice, actually. That's your call.
And how do you know if you've left the system for both medical and indemnity, or versus one or the other?
That's pretty easy. You're going to have an agreement that you signed if you did take a 32, and it's going to say whether you closed medical or indemnity or both. If you have an attorney, ask the attorney. If you don't, or if you'd rather just contact us and have us look at the paperwork, it's all been filed here, so we will know. So if you want to give us a call and ask us what you took, go on ahead. We'll answer it.
All right, and lastly, if you settle and leave the comp system, would your regular insurer have to cover future medical expenses related to the injured body part?
I can't answer that question. The reason I can't answer that question is I don't know what that insurer is going to say about covering medical care related to a work-related injury. I simply don't know. They might object to it because it happened on the job, or they might not. I don't know. I can tell you that if it's Medicare you're going to, Medicare will cover the care if you have exhausted the money you got for the care. Because you're going to, if you're settling the medical care, you're going to get money. You're going to have to put it in a special account that you can't access for anything except pay for medical care. And then once that's exhausted, Medicare will pick up. I can't tell you what a private health insurer will do, though. I just can't speak for them. All right, new topic, virtual hearings. We've mentioned that you might have a hearing in your comp claim. This is the last topic, Adam, then we're going to go to questions. So I'm saying it to Adam, but that's a note for all the rest of you, too. If you have some questions, you might want to start typing them in there. But our last topic is virtual hearings. We do all of our hearings virtually today. We have not yet gone back to in-person hearings, but we have this virtual hearing software, and it's a good thing we did because we didn't lose any hearings in the pandemic when, like, the unified court system did. They closed down the hearings, we didn't. So what this means is, if you have a hearing, you're going to attend it by virtual hearing, you're going to be getting a hearing notice. The hearing notice will say how to participate in the hearing. You can download an app. I'm sure the attorneys who participate in our system, they've all downloaded the app. So you can get it from Google or from Apple, depending on which one you use. Or your hearing notice will have a website that you can access, and it's going to say, okay, come to this site, put in this code, you're going to move into the hearing. Essentially, it's a teleconference. So if you have a computer or a tablet or even a phone with a camera and a microphone, that's what you're using. If you have the opportunity to use a computer or a tablet rather than a little teeny cell phone, I would recommend you go with the bigger screen. If you can't do that, you can participate via telephone, and the hearing notice will say the phone number and how to do it, because if you need to participate by telephone, the judge calls you. I have to repeat, the judge calls you. You don't phone in, your attorney doesn't phone you. You have to tell us ahead of time that you need to get called, and you need to give us the phone number, and the judge will call you and get you on the line. So the main point here is, number one, you're getting a hearing notice. You're getting it in the U.S. mail. It's going to have the directions. And if you're a worker, you definitely want to be at your hearing, even virtually. Even if you think it doesn't concern you, I'm recommending that you get on to the hearing. All righty. Here's how you follow us at the board. Here's all of our social media. I think that YouTube channel is a good one, don't you, Adam?
I love the YouTube channel, Joe.
How many videos do we have on our YouTube channel, Adam?
Oh, gosh, hundreds.
Hundreds, including videos of these presentations?
Including videos of this presentation and our 101 presentation. We have webinar recordings specifically for providers. We have webinar recordings specifically for insurers. We have webinars specifically for employers. And we have webinars on paid family leave, should you have questions about that.
So you might want to check out our YouTube channel, as well as our other channels there. If we're putting something out on Facebook, it's a valid business thing. Okay, we don't have dancing kittens on our stuff. So the last one is also important. Adam, why don't you tell the folks about that last one?
Yes, that link on your screen is actually not working at the moment, and we apologize for that. But if you want to get email notifications from us, you can go right to our website, scroll down to the bottom of the homepage. There's a button that says Get WCB Notifications, and you can sign up to receive news. You get to choose the topic. So whatever topics you want information on for workers' comp related purposes, you can choose that, and then anytime we have news or updates, you will get notified, and that does include webinar announcements.
Great. All right, so here's the contact info for my office. If you need to reach us, there's the phone, there's the email. Feel free to email us. If you do email us and you're asking about a particular claim, please include the WCB case number. That's going to be helpful. And we do answer those emails pretty promptly. You might get an answer in 5 minutes, or it might take us 30 minutes or an hour to answer you. but you're going to get a pretty prompt answer. And I love when people write to us and thank us for the prompt responses. It might be me writing you your response, by the way, because I do help out on that mailbox. And there's our website. Now, I think it's question time, Alan?
It is.
Adam?
And, we do have a slew of questions that came in throughout the webinar. I know we touched on a few, but many we did not. So we have those, and then we have a bunch of questions that are coming in now. So Joe and I are going to take a couple minutes to review the questions that have come in. If you do have a question, feel free to type it in the chat. We will try and get to it. But for now, we are going to take a quick break to review the questions that have come in, and we will be back with you shortly. Thank you.
All right, we're going to do our questions. Adam's going to read the question. I'm going to answer it so that you get different voices. We do have one participant who is very active with questions, and if that fellow, sorry, I just pinpointed you a little bit. That fellow wants to talk to me offline, I would be very happy to, because we might have some things we might want to discuss to see how we can help people. So you can contact me through the email box. Other than that, now we're just going to straight read the questions that we've gotten.
All right, thank you, Joe. Our first question, which came in very early on here. The doctor I used to see for comp treatment left the practice around the time of COVID-19. No other doctor at the office has offered treatment I need. I've been trying to find a new doctor that can treat me that will also take workers' comp insurance, but they would like a referral. Who can we get this referral from?
All right. In our system, you don't need a referral. I wonder if you're seeking out authorized comp doctors. What I would recommend to this person and anyone else in a similar situation, you want to use an authorized comp doctor, especially if you're in New York. So go to our website and click on providers, and the list is there. You can select a provider based on where you live and what specialty you need. If you have trouble finding an authorized provider on that list, you can send an email to the medical director's office, and they'll send you a list. That would be mdo@wcb.ny.gov. If you come to our website, you can find that address, or Adam has very nicely typed that into the chat box for you. I like the way you do that. So they'll send you a list of doctors of the right specialty near you. So we do have a resource for that. The whole matter of referrals, you don't need a referral to go to a doctor. It's not like private health insurance here. You don't need a specific referral.
All right, next question. If an employee is on short-term disability and needs to extend it, does the employee have to fill out the forms again?
What do you mean extend it? This is an instance where if you're on short-term disability and the doctor has opined that you can't work, okay, so you're just going to use that. If the doctor gave an end date of your disability, okay, you're going to have to go back to the doctor and get another opinion. So, yeah, so to that extent, you may or may not have to fill out the form again. The important thing in that case is don't worry about filling out the form. You need the doctor's opinion. That's much more important. So I don't think you have to fill out the form again, but it's all going to be based upon the doctor's opinion. And it only goes up to 26 weeks, by the way. You can only do 26 weeks on short-term disability.
Right, will disability benefits drop automatically without a hearing?
Okay, so when this person says disability, I'm assuming workers' comp, okay? Because disability is its own thing, it's $170 a week. But, okay, people sometimes use the terms interchangeably. Will the workers' comp benefit drop automatically without a hearing? It certainly can if, number one, there's no CCP in place. Number two, the worker is temporary. And number three, the opinion of the doctor has changed the disability level to a lower level. So, you were going along at 100, now you get a 50%. Yes, the insurance payer can change your benefits. And also, just so you know, let's say there's no CCP and you go to an IME. I'm sorry to use all those acronyms, but let's say there's no carrier continue payments and you attend an independent medical exam, and that independent medical exam brings you in at a lower degree of disability, yes, the payer can reduce your payments. That's the point where if you have a lawyer, you want to talk to your lawyer about maybe I need a hearing to have a judge make a decision.
If a worker's claim is denied by the carrier, does the carrier still have to pay for medical appointments while the hearing is ongoing, or can the employee receive disability benefits if a claim is denied pending trial?
Okay, we have two questions there. So, number one, yeah, we kind of were saying this earlier. If the claim is denied by the carrier or it's controverted and it's in hearings, the carrier is not going to pay for any of the medical appointments until a decision comes down. Can the worker get treatment? Of course, please go get treatment. If you're going to authorized providers, they know they may have to wait. That's the virtue of using authorized providers. They know the rules. So that's number one. Number two, the other end of that question, yes, we did talk about this. Yes, you may receive short-term disability while your comp claim is being litigated. Yes, that's why we mentioned short-term disability to you, because a lot of people don't seem to know that. If you're eligible for it, go ahead and file for short-term disability.
When is the latest in a claim that a representative can file the OC 400?
Okay, this worker is asking about the OC 400 pertains to a fee for service from a representative. When's the latest they can file it? Well, they're certainly going to file it at the end of the claim. If you're asking me the statute of limitations, I'm sorry, I don't have that available off the top of my head. I'm sure that we've answered that question on our website somewhere or in the announcements regarding the OC 400 form. I know that there was an announcement recently about that.
We have a question here. Someone's looking for more information explaining the LWEC calculation. We do have information on our website. If you go to wcb.ny.gov, in the upper right-hand corner, there's a search bar, and if you just type in LWEC or anything related to that, we should get a number of information that pops up that you can take a look at.
I believe that this might be covered in the permanent impairment guidelines. I just want to make everyone aware, if you are really going to pursue understanding how LWEC is calculated, that would be grad school, okay? If this is the 202, that would be grad school. It's complex, but go on ahead.
Are injured workers eligible for reimbursement of paid time off, such as sick or holiday, vacation pay, while they're under workers' comp?
All right, here's how this goes. Now, you're asking me a workplace question, and in a lot of instances that have to do with workplace questions, the rules of your workplace are going to prevail, or Department of Labor rules are going to prevail. We're not going to really have any say over here at this agency. So what I'm about to say is this. Don't forget that the workers' comp benefit is a 2/3 benefit, as in you're going to get 2/3 of your benefit. So let's say you were injured, and while your claim is being litigated, your employer lets you use paid time off to get 100% of your pay. Okay, so now your claim's established, and you're going to get 2/3 of the pay from comp, so that 1/3 is still outstanding. Well, if the employer lets you use your paid time off for that 1/3, then you should get the 2/3 of the time that you use restored to you because you were out on comp. But if you're going for the full pay, you would still have to use your paid time off for that other 1/3.
How can a claim be open but not established? What is required to get the claim established?
Oh, well, I'm glad you asked that question because we sort of assume you realize this, but here we go. How can a claim be opened? Okay, so we've gotten notice that there was an incident and a medical report. The claim is open. How can it be open but not established? Because established is step 2. When we say a claim is established, that means it is, for want of a better word, a valid payable workers' comp claim. That's what established means. So if your claim is being denied by the insurance company or controverted, it's not yet established. You're going to get a decision that's either going to establish it or deny it.
What is the formula for settlement payment? So, for example, in our scenario, Susan is 50% disabled and receives $500 a week for 3 years. How is that calculated?
Okay, so what's the formula for settlement payments? Well, remember, I'm trusting that you're using settlement correctly now. A settlement is Section 32. So what's the formula for a Section 32 payment? I can't tell you. It's whatever the worker and the insurance company have agreed to.
Right, so what if you refer to the same IEC doctor twice?
Okay, so our questioner, you might want to clarify IEC because we're not familiar with that acronym. We are wondering if you mean IME, the Independent Medical Examiner. And so what if you referred to the same Independent Medical Examiner twice? Well, then you're going to see the same IME twice. That's okay. Sometimes you do get referred to the same IME twice. Yeah, maybe it's the only doctor in that specialty in your area.
What if you were declined surgery for other injury parts because one of your injuries is still serious?
Okay, so someone is asking us a very specific medical question. This is too broad a medical question to really give you a comp answer. It appears to us like you're talking about medical care, and I know this is the comp system, but the overriding thing is still your health. So please, my friends, see your doctors and get the treatment that you really need, and just like put comp aside for 1 second. Just make sure you're getting the care that you need. And yes, I understand, then you may have to turn to the comp side. So that's when we'll try and help you with that. Oh, how about the private taxis?
Are private taxis or car services like Uber, Lyft, are they covered for reimbursement if you cannot legally drive because of your injury?
They are covered for reimbursement for travel to and from your care or travel to and from your IME appointments. Yes. Now, sometimes the payers wish to object to the fees. They don't have to object, and if they want to pay you less than what the car service charged you, then you're going to have a hearing, and a judge is going to consider it. Someone is asking an extremely technical legal question. I'm very sorry. I can't answer this very technical legal question. It has to do with administrative decisions and proposed decisions, and why aren't they simply amended when they're objected to? I'm sorry, I really can't answer that very technical question. Number one is I'm having a little difficulty following it. Number two, I'm not an attorney. Number three is it's extremely technical. So I would suggest to this person, that's the kind of question that you might want to flesh out a little bit and send it either to us in my office or more pertinently to the Office of General Counsel. Because our Office of General Counsel does take email. They won't give you legal advice, but they can answer those kinds of very technical legal questions. And thank you for the compliment, by the way, on the webinar. Oh, look, Adam, there's another thank you. What do we have next?
This is another, I think, medical question here. If a surgery has been approved without prejudice, the provider the injured worker wants to do the surgery will not proceed until the decision has been made. How and when will the decision be made?
All right, this one I know what's up. A surgery has been approved without prejudice. Okay, when that is stated in the authorization, it means that there's an element of the claim that is as yet unresolved or unestablished. Well, the surgeon is objecting to doing the surgery without that approval, without that establishment. Okay. Well, number one, contact the medical director's office. Okay? Give your claim number and your surgery and your surgeon's name and practice, and tell them about it, because they can have a conversation with the medical office on this. Okay? They just need the details. So that's what I'm going to recommend you go on and do there. You could also possibly see another surgeon, but I would defer that one to the medical director's office. Let them handle that one, because we do, from the MDO, medical director's office, we do speak with providers all the time, not only on these little things, but also on general education. And if you're a provider and you're still on with us, I would encourage you to have their contact info readily available.
All right, we got two more questions here. First one, I've been trying to fax documents in relation to the unemployment insurance notice of potential charges, but the forms are not going through.
Okay, I do believe that this person is trying to contact unemployment insurance at the Department of Labor. That's not us. We are a different agency. I am going to recommend you go to the New York State Department of Labor website and check their contact info. I'm also going to say that maybe there's another way beyond faxing to get those documents there, but that might ultimately be easier for you. But you need to go to the New York State Department of Labor site.
All right, our last question here. When do I know a claim is established?
There's going to be a document released from the board that is going to say it. It might come after a hearing, or it might come after a year and a day if the claim was accepted by the payer in a particular way known as 21A. But there will be something from the board that will say it. If you're wondering, give us a call. Send us an email. See that info right there on screen? Go on ahead. If you email that question into that mailbox with your case number, that's a really easy one. I can answer that one in like 2 minutes.
All right. Thank you, Joe. That is all the questions we have, so we are going to go ahead and wrap up. I want to thank you all for joining us. As always, we greatly appreciate your participation. I want to thank Joe for taking the time to give this presentation and answer all of your questions. Just one more reminder that you can sign up to receive workers' compensation news, including information on future webinars, straight to your inbox, including this one. To sign up, just visit our website, scroll down to the bottom of the homepage, and select Get WCB Notifications. Joe had mentioned this, and we briefly discussed, we do also distribute information on social media. So make sure you're following the board on Facebook, X, which is formerly known as Twitter, Instagram, and YouTube. Again, that YouTube channel, we have dozens upon dozens of videos and webinar recordings that can be very helpful to you.